camera photo. Welcome to Banik's YouTube class for civil service examination. We are here to discuss the rest part of Supreme Court. Last class we had already completed the details about Supreme Court composition and strength and removal procedure of the judges of Supreme Court and the appointment qualifications of everything related to them. I hope you have gone through the class well and understood the concept. Today we shall start with the rest part of jurisdiction. We had already focused on original jurisdiction of the Supreme Court, and as you know, as the Supreme Court is a federal court, it is the sole authority to decide the cases or disputes arising or disputes between the center and states and between the center on one side and the states on the other side, between center and one or more state on one side and the other states on the other side, and also between or among the states. So federal disputes are decided by the Supreme Court, but certain federal aspects like the interstate river disputes or the disputes arising out of the financial recommendation of the Finance Commission of India are not decided by the Supreme Court. There has been an alternative arrangement. So we can say that as a federal Supreme Court, as a federal court, Supreme Court has more important responsibilities, and it is essential in this respect that a federal court to be there to strengthen the federal balance and to strengthen the federal bonding between the center and states in the larger interest of the unity, integrity and sovereignty of India. Okay? So that is the things about. Then that is also, this matter is also important because disputes related to pre-constitutional treaties, agreements that arise out of that is not a original jurisdiction of the Constitution. Then appellate jurisdiction. Under Article 132 and 135, there is a range of appellate jurisdictions provided in the Constitution. The Supreme Court not only deals with the criminal civil cases, but also on the constitutional matters. It hears appeal from against judgment of any court or tribunal in matters of civil, criminal and judicial constitutional cases. So it is the highest court of appeal. It hears appeals against the judgment of any court or tribunal in civil, criminal and constitutional cases. So that is called the appellate jurisdiction. Sometimes High Court may certify some cases for the appeal, and that is called appellate jurisdictions. Then we have special jurisdiction, special leave petition 136. It is a matter that under this jurisdiction, the Supreme Court can withdraw any matter undecided or decided from any court or tribunal and decide on its own if it thinks that it involves substantial constitutional matters. That means it can withdraw, it can take away any judgment, any case pending or decided by any court or tribunal, and the Supreme Court decides on its own if it thinks or if it pertains to any substantial matters of the Constitution. But the special leave petitions under Article 136 is sparingly used in extraordinary circumstances. That does not mean that the Supreme Court can withdraw any time at any case from any court at any time. It is used in exceptional cases where lots of substantial constitutional matters are related and which requires the involvement of the Supreme Court. So special leave petition is a rare kind of powers enjoyed by the Supreme Court in extraordinary or exceptional circumstances. That is called special leave petitions. Then we have advisory jurisdiction. The advisory jurisdiction has been borrowed from the Canadian Constitution, if you remember, under Article 143 of the Constitution. Then the President, under this jurisdiction, what happens? The Supreme Court tenders advice to the President if it seeks, if the latter seeks it from the former in pre-constitutional and constitutional matters. There are two matters on which the Supreme Court can tender advice. One is pre-constitutional treaties, and agreements, etc. That means concluded before 26 January 1950. Before 1950, if some treaties and agreements were concluded, and if there is a dispute over that, over the subject matter of the treaty and agreements, then it may be referred to the Supreme Court, and Supreme Court as that is, he must tender advice, And number two, in the constitutional issues, in the constitutional matters related to any law, any article, any provisions, that is may tender. So you can see the word must tender and may tender. In case of pre-constitutional treaties and agreements, the Supreme Court is bound to tender its advice. But in constitutional matters, Supreme Court may or may not tender its advice, it may delay it. So it is therefore of two types. One is binding in nature, another is not binding in nature. The matters related to pre-constitutional treaties and agreements are binding in nature. The matters related to constitutional issues and laws, legal issues are not non-binding in nature. But the advice tendered by the Supreme Court on these matters, are not binding upon the President. Under Article 143 of the Constitution, it is not binding upon the Constitution. Okay? So that is also a part of things we have to remember, that it may not be binding upon the President. So you can take a note of that. Under Article 143, Supreme Court tenders advice on pre-constitutional and post-constitutional matters, and the advice tendered by the Supreme Court is not binding upon the President. And Supreme Court's advisory power is because of the Supreme Court's, the highest court or highest judiciarian is the sole interpreter of the Constitution. Hence, a type of advisory power is added, but it is not enjoyed by the high courts. That is called advisory jurisdiction. Kindly remember the Article 143 about that. 133, that is writ jurisdiction. Writ jurisdiction of Supreme Court deals with the power of Supreme Court to issue certain judicial writs, that is, like we have discussed, habeas corpus, mandamus, so on, for the enforcement of fundamental rights. So writ power is a special kind of power. It is conferred upon the courts by the Parliament through an act, and writ power is enjoyed by the Supreme Court under Article 32 also to issue writs for the enforcement of the fundamental rights, because you know that Supreme Court is the custodian or the protector of fundamental rights. And Article 32 empowers the common man to move the Supreme Court for the enforcement of fundamental rights. Supreme Court is approachable, accessible by the common man only through Article 32. That is also a point to be remembered. That a common man cannot approach Supreme Court directly on any other matter except violation of fundamental rights. And under Article 32, it is also a fact that Supreme Court cannot deny, shall not deny, to entertain any matter related to 32. It cannot deny also. It is bound to involve in the matter when it is related to violation of the fundamental rights. So on writ jurisdiction is in fact is a borrowing from the American pattern, American system, and under this the Supreme Court issues writs of mandamus, habeas corpus, quo warranto, prohibition and certiorari for the enforcement of fundamental rights. And remember, it is the only article that empowers the common man to approach the Supreme Court, and the Supreme Court shall not deny to entertain any matter related to the fundamental rights, but 32 cannot be applied to any other matter except fundamental rights. So, that is a kind of jurisdiction called writ power of the Supreme Court. Then revisory power, that is revisionary or revisory jurisdiction, that is article 137, revisory. Revisory means that the Supreme Court has the authority to revise its own judgment. It can revise its own judgment. It can may not uphold the earlier judgment. It may overrule the judgment, and it may have a new judgment in its place. So, Supreme Court has got the authority to change its own judgment, to revise its own verdicts, and that is called the revisory power under article 137. It is a constitutional provision. No other court can alter or change the judgment of the Supreme Court. It is only the Supreme Court which is empowered to change its own judgment to cope with the changing time. So, that is called a revisory power of the Supreme Court. Then guardian of the Constitution. Supreme Court is the guardian of the Constitution. It ensures that no other organs of the government, no other institution, no other authority in the country violates the Constitution. It is the sole protector and defender, custodian of the Constitution. So, as a guardian of the Constitution, Supreme Court performs manifold duties and manifold functions. It ensures, it examines every act, it ensures that no institution, whether built or newly built or old institution, whatever it may be, but they should not violate the Constitution to any extent. That is the guardian. So, it is very simple to write about guardian of the Constitution. Then power of judicial review. Supreme Court has power of judicial review, and that is, yes, that is there. Supreme Court is a power of judicial review, and that judicial review is a power mentioned, or it is derived from many articles 13, 32 to 26. Judicial power is very widely mentioned in the Constitution through various articles. It is given 372 related to pre-constitutional acts. So, various articles empowers or gives the court the power of judicial review. And what is reviewed in this case? Any enactments, the judiciary or the Supreme Court reviews, not only the Supreme Court but also the High Court also, but we shall write here the Supreme Court. The Supreme Court reviews any acts, legislative acts enacted by Parliament and state legislature, executive orders, ordinances, bylaws, anything that is there in India to ascertain, to establish, that it does not violate the Constitution. Such act does not violate the Constitution. Such act does not violate the fundamental rights. And number 3, it is made by competent authority. It is made by competent authority. So, that is a point to be remembered, that on 3 grounds the Supreme Court examines the judicial review, and judicial review makes the Constitution written and makes the Constitution more accountable, more responsible towards the people. Constitution requires to be protected by the court, and in this way the Constitution is protected. Judicial review is a greatest ammunition or greatest weapon in the hand of the judiciary to protect the democratic spirit of the Constitution, to ensure that Constitution is not violated or hurt. So, when any act comes before it, it ensures these three factors, that whether such act violates the Constitution, whether such acts violates the fundamental rights, whether such act is made by any competent authority. Competent authority means the authority which is empowered or which is the right authority to make the law, not other authority. The authority who does not have to make the law, they cannot make it. So, in this way the power of judicial review is exercised. It is a basic structure of the Constitution. In various cases, the Supreme Court has said that it is a basic structure of the Constitution. We cannot review it, we cannot take out it. It is an inherent provision of the Constitution. Article 13, 20, 32, 26, 372, 245, 252, various articles are there. Are lots of articles which contains the power of judicial review. So, this is a unique power, and this is a fundamental characteristic of our Constitution, and it is also a basic structure in the Indian Constitution. Then court of record under Article 129. Court of record. Court of record means that Supreme Court judgments, verdicts are preserved for perennial references, for future references. Judgments are preserved, recorded for the future purposes. And also it means that the Supreme Court has the power to punish for its own contempt whenever any offense, any criminal attitude is shown to the judiciary, or any violence, any type of things that are considered or that constitute the contempt of court will be decided by the court itself. So, court of record means two things. One is preservation of the judgments, preservation of the judgments and verdicts of the Supreme Court for future reference, and number two, Supreme Court has the power to punish for its own contempt. So, court of record, and it is a Supreme Court is a court of record under Article 2129, and there is also High Court is a court of record under Article 215. So, these are the basic powers of the Supreme Court: original powers, appellate powers, writ powers, revisory powers, special leave powers, and your advisory powers. Then your court of record is also a kind of power. Apart from these powers, the Supreme Court also deals with certain extraordinary or certain important matters of the country, that it decides disputes related to the election of the president and vice president. It is also a unique function of the Supreme Court. Whenever any dispute arises over the election of the vice president and president, it is the Supreme Court which decides the case, not the Election Commission of India to that extent. And recommends for removal of the UPSC chairman and persons, not only UPSC chairman, but also there are various authorities which are also removed in this manner, like the NHRC chairperson and members, Central Information Commission chairman and members, OPSC State Public Service Commission chairman and members. They are also made when they are removed on the basis of misbehavior. If the members are removed, members or chairpersons are removed on the basis of misbehavior, then a reference will be made to the Supreme Court. After Supreme Court investigates the matter and reports or finds the person guilty, then there will be the president will remove him. So, that is also a power. It recommends removal of the UPSC chairperson and members and others also. Judicial superintendence over all over the courts and tribunals except any excluded by the parliament. Judicial superintendence is there, the functioning, the control, the management of the courts, the functioning of the courts, the rules and regulations to be followed in the courts are decided by are finally approved by the Supreme Court. Judicial superintendence over determines practice and procedure of the court on the approval of the president, in what way, in what manner the courts will function, that is decided by the Supreme Court with the prior sanction of the president. Complete administrative control over its establishment is also a power that it has its own control over its administrative staff. It appoints them, it decides the salary, it removes them, and it decides everything, every matter related to the employee. So these are the other powers of the president. So it is a vast or large code, deals with multifarious activities as we have seen. Okay, as we have seen. And there are important articles we have mentioned here. You can see 124 establishment and constitution, everything like qualifications and resignations and oath, permissions, removal, everything is mentioned in article 124. 126 is the appointment of acting Chief Justice, and 127 is the ad hoc judges. We have already discussed ad hoc judges. And 129 the Supreme Court records, then there is original jurisdiction up to, that is 36, and 39 also contains power to issue writs, although 32 under 32 it is issued, but the Supreme Court's powers to issue writs lies in 139, and there is one particular articles, that is 141 article 141, that is the laws or judgments declared by the Supreme Court, shall be binding across the country. Okay, so these are the important articles of the Supreme Court. Kindly remember that. Then we shall come to the MCQs on the questions. Okay. Under which of the following acts a federal Supreme Court was established before the independence of India? That is, Government of India Act 1935, and it was established on 1st April 1937. 1st April 1937. That is B. And the court was established on 1st April 1937. The present Supreme Court of India was established in 1950, 28 January 1950. Okay. Then which of the following articles contains the composition, appointment and removal of the judges of Supreme Court? It is composition, appointment and judges of the Supreme Court is mentioned in Article 124 of the Constitution. 124. That is answer A. Which of the following articles contains the provision of appointment of ad hoc judges? That is 127. 127. Ad hoc judges are appointed to fill up the vacancy or the quorum if there is a lack of quorum. Which of the following articles contains the provision of appointment of acting Chief Justice? 126. acting Chief Justice of India is 126, and in 3 circumstances the acting Chief Justice shall be appointed. We have already discussed all these things, in what circumstances the President appoints the acting Chief Justice, that is D, that is C. The judges of court are appointed by the President in consultation with the CJI and other judges, so that is not mentioned, so better is, that is B. Okay. So is this clear? Next, 128 is regarding the article 128 is regarding the attendance or allowing the retired judges to serve as the judge of Supreme Court. Which of the following is not a qualifications to become a judge of Supreme Court of India? Citizen of India, judge of High Court 5 years, 10 years. Practitioner in district court is not required. So answer D. Power of Supreme Court to use special petition is given under article 137, that is we have discussed, rarely used. The strength of Supreme Court is decided by Parliament through an act. D. Parliament through an act. So this is question number 9. Remember, the strength is decided by the Parliament, not by the Supreme President. Who became the first Chief Justice of India? That is very easy question. Harilal, Jesudas, Jaikishan Das, Kenya. That is A. Who among the following is the longest serving Chief Justice of India? Yashwant Vishnu Chandrachud. A. Y.V. Chandrachud. What is the tenure of the CJI? Not term specified. There is no specific term of the CJI or the judges. They can continue until they attain the age of 65. So kindly take a note of this. That is which of the following does not come under the original jurisdiction of the Supreme Court? Original jurisdiction. That is the center-state disputes, disputes between states, interstate river disputes, That is C. Interstate river dispute does not come under the original jurisdiction of the Supreme Court. Ad hoc judges are appointed by the CJI with the prior approval of the President. Best answer D. The judges of the Supreme Court shall be binding across the country. That is Article 141. Nobody can defy, nobody can challenge the judgment of the Supreme Court. That is answer A. So now we will come to the question number 19. Which of the following is incorrect regarding the advisory jurisdiction of the Supreme Court? It is provided under Article 143. Supreme Court is bound to give judgment on matters in the post-constitution period. Supreme Court is bound to judgment on pre-constitution matters. The advice of the Supreme Court is not binding. So that will be answer B. Answer B. Supreme Court is bound to give judgment on the post-constitution, but not bound. Not bound. The first ODI to become the Chief Justice of India is Justice Ranganath Mishra in 1992. Justice Ranganath Mishra. And there have been 3 ODIs. So this is all about your Supreme Court. Next class we shall describe the High Courts. So let me just introduce you High Courts, then we shall begin with the rest part, the High Courts in India. High courts are also comes after the Supreme Court. High courts are provided for each state. High court is also a type of IAS judiciary at the state level. It is as independent as Supreme Court. It doesn't mean that it is functions directly under the control of the Supreme Court. It has its own autonomy. And to be right, we can say that high courts are were the first to be established in India. So the establishment of high court can be traced back to 19th century, latter part of 19th century. That means high courts were there even before independence. And high courts deals with matters or disputes related to state list and concurrent list. Any disputes arising over that, it will decide the matter. It does not decide the federal disputes, and it has more functions than the Supreme Court, so to say, because it involved in the day-to-day functioning of the state, and also also the matters related to individuals. So High Court is placed at the middle of the judicial hierarchy, and it is considered the highest judiciary of the state. They are mentioned in part 6. High courts are mentioned in part 6. Part 6 in article 2142, 237. 2142 through 232. But if you go back to the, if you look at the history of high courts, you will find that the first high court was set up in 1862 in Calcutta. The second high court was set up in 1862 in Bombay, and then in Madras also in the same year. It means that 3 high courts were set up in the same year, that is 1962, under High Court Act, Indian High Court Act 1861. And the high court simultaneously functioned in latter in 1766. In 1766, the High Court Calcutta, the Allahabad High Court was established, and in 1884, Mysore High Court was established. In 1928, Jammu Kashmir High Court was established. So later it goes on, and various high courts were set up at different types of years, and they have a different type of headquarters also. Okay, so the article 121, article 214 says that deals with the organization of the high courts, and it says that there shall be a high court for each state. But Parliament has amended for the 7th Amendment Act 1956. It is provided that Parliament can constitute a common high court under Article 231 for 2 or more states. For having a court, high court in a small state, it's very quite expensive, probably for these reasons that common high courts are provided. And common high courts are established by an act of Parliament. Okay, and so far India has 3 common high courts in India. Okay, so let me come to serially that the history of high courts. If you say that first high court, history of high courts, first high court is Calcutta in 1872, 1862, and number 2, second high court, that is Bombay, 1862, and number 3, third high court, that is Madras, 1862, and established under Indian High Court Act 1861. And in 1866, Allahabad High Court was established. Then you can say 1884, Mysore High Court, Karnataka High Court. That is 1884, Karnataka High Court. That was established in Mysore High Court, 1884. And then 1928, Jammu Kashmir High Court. Then you can have other high courts also. Okay, other high courts also. In 1928, then 1949 Rajasthan High Court. That is 1949. Okay. Then 1956 बहुत सारा कोर्ट अच्छी 1956 रे MP High Court, Madhya Pradesh High Court. Okay, kindly take a note of this. Then we have, after Rajasthan, there will be 1954, Telangana High Court. Just a minute. 1954, that is 1954. That is Hyderabad High Court, so Andhra High Court jete jibo. 49 Rajasthan. 1954 re Hyderabad High Court jota Andhra High Court la, now it is called Telangana High Court. And 1956 re MP और 1956 re Kerala. But we have forgotten that in 1948 also Odisha High Court was established. Kindly take a note of this. So in 1916 another court is there, 1916 Patna High Court. And if we consider both Punjab High Court, then it will be 1875. Punjab High Court, but Punjab and Haryana High Court today they are called. Okay. Now, in 1971, 1966, 1960 also there, Gujarat High Court. 1960. Gujarat High Court, 1966 Delhi High Court, okay. Then apart from that, there are also some courts like Gujarat, Himachal Pradesh 1971, Himachal Pradesh, it was established in the year in which your state was established, 1971. Then we have Jharkhand 2000, Jharkhand, Chhattisgarh, Jharkhand 2000. Then we have also Chhattisgarh High Court 2000. Then you have also your Uttarakhand High Court 2000. Uttarakhand High Court 2000, 1975 Sikkim High Court. Sikkim has also a High Court. So in 2013, that is Meghalaya, Manipur and Tripura. So these are the just giving you an idea about the establishment, but you can go through the list of the high courts provided in books and internet and have a command over that, which high court was established in which year. Okay. In the next class, we shall be starting the chapter High Courts and Subordinate Courts in India. We shall discuss lot of things, and also we shall discuss the headquarters. You will see that some high courts have their headquarters in the state capital, but some do not have their headquarters in the state capital. For example, Rajasthan has its headquarters in Jodhpur, and Madhya Pradesh have its in Bilaspur, Bilaspur, and in Chhattisgarh also there is a headquarters of Jabalpur. Chhattisgarh has its headquarters in Bilaspur, and Madhya Pradesh has its headquarters in Jabalpur. So different. Kochi, Kerala's headquarters is in Kochi, Ernakulam districts. So they are not located in the state capital. In this way, you have to differentiate or distinguish these things, which state capital, which high courts have their headquarters in the state capital, which high courts do not have their headquarters in the state capitals. So in the next class, we shall be summarizing all these things, and also we shall start the powers, the procedure of qualification, appointment, oaths, all these things related to high courts. Till then, let me bid you goodbye. Stay home and stay prepared, and watch Baning's YouTube special classes for civil service for your improvement and betterment. Thank you very much. Okay.